Mr. Flanagan.
Lord, got one final point on the statutory context, which is Section 3,
Yep.
so going on Section 21. And I do place some reliance on Section 3, and I say it further supports the Secretary of State's approach, as in the absence of a positive duty to comply in Section 21, contrasted with the positive duty to comply in Section 3. There is clearly an obvious reason why you have a specific duty to comply in the Section 3 context, because you have an additional party in the form of the Strategic Highways Company, and that company depends on the Secretary of State for funding and will be entering into contracts and things of that sort dependent on that funding. So you need a enforceable mechanism that funding does actually materialise. But Parliament has chosen to impose that specific duty in Section 3, but not considered that any similar express duty to comply is necessary for Section 21. And I say that further indicates that there is no implicit duty to that effect either, and it doesn't cut down the Secretary of State's common law power to make budgetary decisions on active travel funding. So that's Section 3. And I then got 2 points on the wider context, which I say are also relevant to the interpretation of the statute. And the first is about practicality and what Parliament could have intended realistically. And I say the current scenario is quite illustrative. The Chancellor made a decision, an announcement on the 22nd of November 2022, that departments were going to have to reduce their capital spending because of pressures from inflation in Ukraine and those matters of those sort. And made a decision that process, that government-wide process of reducing spending to live within means, was to be concluded by March 2023, so within 4 months. And you see in Miss Matthews' witness statement what then happened in the Department for Transport, where there was consideration of how that was to be achieved, and it was essentially a comprehensive review of spending, capital spending within the department. On the appellant's approach, active travel dedicated funding would be essentially immune from that process and not able to be factored into it without having gone through the variation procedure in Section 21, which that mandatory procedural hurdle, I say, would be totally impractical.
Why?
Because, firstly, because of time. In the 4-month period, it's particularly tight to do it. Secondly, because you can't meaningfully consult until you know what the reduction is going to be, or broadly is going to be. And you don't know that until the end of the process, because it's a comprehensive review. And not just comprehensive within the department, there also may be pressures from other departments, which may play into the final decision. So you couldn't go out to consultation in January saying we're going to reduce active travel funding by this amount, because you don't know that in January. You only know it on the 9th of March when the final decision's made. As to then whether you could do some consultation and variation after the 9th of March, well, that would be retrospective. The decision would have been made. It would be not meaningful consultation, obviously. So that would be the effect of, I say, learning friends' interpretation and approach. It would prevent that happening. And the extreme impracticality of that, I say, is something that cannot be attributed to Parliament. Reading Section 21, it would need very clear words to that effect, of which there are none. The second, and it's a more subsidiary point about context, is that you have Miss Matthews' evidence about the complexity of active travel funding coming from various sources, depending on percentages of funds which are assumed to go to active travel. It's the opposite of an exact science, predicting active travel funding. And for that reason also, I say that Section 21 can't be read as essentially tying the Secretary of State to the figure in the strategy unless a formal variation is gone through, because to start with, it is a high-level estimate based on many moving parts, which is a best projection, no more than that. So it doesn't reflect the reality of what it's dealing with, Mullin and Friend's interpretation of Section 21. I'm conscious that Mullin and Friend responds to that by saying, well, dedicated funding is more predictable because it's more ring-fenced potentially. It doesn't depend on percentages of funds which could go up or down in bids and those sorts of things of those sort. That is true, but Section 21 is only concerned with resources globally to be made available. Section 21 doesn't descend into dedicated, non-dedicated funding or anything of that sort. You only find that in the strategy itself. So given that Section 21 is only interested in the total funding, the resources to be made available, and that is inevitably a fluctuating and hard to predict figure, it's, again, I say, unrealistic to suggest that Parliament would time the Secretary of State to that figure, absent a formal variation approach. So those, I say, 2 points of context which I say are particularly compelling and reinforce the plain words. I was then going to turn to the authorities. I say there are 3. I could first go to the Shrewsbury case, which is in tab 5.
Page
Starts at page 112, and the passage I rely on is at page 128.
Thank you.
And it's under the subheading Inconsistency with Statute. This is Lord Justice Carnwath's judgment as it then was, and it essentially brings together the authorities on this principle. And it's useful, I say, because it's important to see how the court characterises this principle that my learned friend relies on. So paragraph 50, there's no dispute that whatever the scope of the Secretary of State's common law powers, they may be expressly or implicitly excluded by a statutory scheme covering the same subject. So, say, the question is whether Section 21 is excluding or expressly or implicitly excluding the common law power which the Secretary of State has to make budget decisions. And there's no dispute about the existence of that power to conduct the ordinary business of government, which would include making budget decisions. And then Lord Justice Carnwath quotes from Lord Brown Wilkinson in Fire Brigades Union, which my learned friend pointed to, but I agree it is a central statement that, still on the same page at G, F to G, if Parliament has conferred on the executive statutory powers to do a particular act, that act can only thereafter be done under the statutory powers so conferred. Any pre-existing prerogative power to do the same act is pro tanto excluded. And I say that the act with which Section 21 is concerned is setting a strategy, an investment strategy. That is not the same act as, a few years later, reducing a particular part of the budget with which that strategy is concerned.
And how do you deal with the point that the strategy must specify financial resources?
Because because that is the act with which the section concerns specifying resources. What happens later is that there's a decision to reduce some of those resources, or not make them available to the same extent. So it's not the case where the Fire Brigades Union, for example, where you had a Parliament suggesting there should be a specific type of statutory scheme and the Secretary of State bringing in a different type of statutory scheme where there's a flat inconsistency. Here it's 2 different acts, and although they're obviously interrelated, I say that this principle doesn't apply. And the only other dictionary I rely on from this case is over a couple of pages at paragraph 57, where Lord Justice Calmer says, in my view, that simple analysis ignores the context in which the courts enunciated these principles. The inconsistency principles was developed by the courts in response to attempts by the executive to override statutory controls in a way which materially affected private or public rights. So that characterisation of whether what is going on is overriding statutory controls, and for the same reasons I say making a budgetary decision is not overriding the statute, which is concerned with specifying an investment strategy. They're two different decisions. That's what I say about Shrewsbury. The Fire Brigades Union, tab 4. Just look at that. We looked at Lord Brown Wilkinson's speech. Just wanted to pick up something from Lord Nichols, which is at 5. Starts at the bottom of bundle page 108, which is 575 of the report. And within the paragraph at the bottom of that page, this statutory duty, if I could just pick it over the page, top of page 576, 4 lines in, Lord Nichols says, the executive cannot exercise the prerogative power in a way which would derogate from the due fulfilment of a statutory duty. To that extent, the exercise of prerogative power is curtailed so long as the statutory duty continues to exist. And so forth. So, in Fire Brigades Union, indeed with the leading authority on this, it's characterised as asking whether the decision maker is derogating from the fulfilment of a statutory duty, frustrating the will of Parliament in some way. And again, applying that to the facts of the present case, making a budgetary decision which may not mean that the investment strategy is fulfilled, but it can't be said to be derogating, in my opinion, from the Section 21 duty to specify a strategy with resources in it.
And what do you say the answer to Mr. Forsyth's point is, that the statutory duty is to vary in accordance with the Act, and you are frustrating the will of Parliament by not varying in accordance with the provisions?
I say that you don't frustrate the duty to vary in accordance with the Act unless you seek to vary your strategy. And the decision in this case was not to seek to vary the strategy remained in place. No doubt when the new strategy, the third cycling and watering strategy, was being promulgated, which Leonard Fred correctly said is happening at the moment, it may be decided that strategy, as a result of these budgetary decisions, looks different to the previous one. But that, in my submission, doesn't mean you have to vary the previous one.
Thank you.
So that's Fire Brigades Union. And then finally, Great Portland Estates, which is tab 3. And I make a similar point. And it's bundle page 44 in the speech of Lord Scarlett. And on that page, so 674 of the report, and it starts at D, middle of the page. Lord Scarman says, the statute requires a local plan shall formulate in such detail as the council thinks appropriate their proposals for development and use of land, reference to the statute. If a local planning authority has proposals of policy for the development and use of land in its area, which it chooses to exclude from the plan, it is, in my judgment, failing in its statutory duty. So again, the characterisation, as in Fire Brigades Union, is essentially derogating from a statutory duty. And that's what gives rise to the unlawfulness, both in Fibre Codes Union and Great Portland, which meant the decision maker couldn't do what they did. And on that basis, again, I say that's not what's going on in the present case. So those are my submissions on the first topic of my submission, section 21, its context and its interpretation. I then turn to the second strand of the argument, which is what the strategy, the second cycle walking strategy, actually says, on the basis that I say that it is an estimate, a total estimate, and therefore, for that further reason, the decision to reduce funding is not inconsistent with it. And this is essentially a standalone point. Even if I'm wrong on the interpretation of the statute, I say this point means that if I was successful on this point, I still succeed. On the basis that even if the statute is more strict, the strategy is worded flexibly enough that what happened could happen compatibly with the strategy and the statute.
So is this a fair summary, that there was therefore compliance with the strategy, so it wasn't a variation? Yeah.
And you can take it to the strategy already, you just pick up the relevant parts for my purposes. It's in the supplementary bundle, starting at page 11. And page 11 is where section 2, which is the financial resources section of the strategy, begins. And the strategy is like section 21.3, divided into two sections, the first on objectives, the second on financial resources. And the first point I make is in, paragraphs are not numbered, under that heading, financial resources, the third full paragraph explains the context of the first strategy, projecting 1.2 billion, but coming up actually with the funding in that period amounting to some 3.2 billion, as you see in the next paragraph. I say that's relevant because when you read what follows, you have to read it again in the context of that, and it implies that what it's talking about is a projection, a figure which is uncertain and may change. Then,
that may be how it's described in the strategy, but the duty imposed by section 21 is to specify something. So to the extent that anything's specified, that's what's specified, isn't it?
But if what's specified is an estimate, then if you depart from your estimate, you're not departing from your strategy because it was only an estimate to start with.
I see.
I mean, and I say it's important that this judicial review is not a challenge to the strategy, and a challenge suggesting that the strategy is insufficiently specific or clear in what funding is going to be delivered, provided, made available. It's only to the decision. And you then, on the same page, you have the three main sources that I took you to, and dedicated, it's the first heading, wider DFT over the page is the programmes is the second heading, and other central government funding is the third heading. Then, having done that, been through that, I say it's important that the actual statement of resources comes under the final heading on that page, page 12, total government funding for active travel, and then the table 1 sets it out, still under that same heading. And it's important I say that the heading is total government funding. Although there are funding lines, the strategy is talking about a total figure. And therefore, reduction in one funding line doesn't necessarily, it's not necessarily inconsistent with the strategy, given it's a total figure and other lines could increase. So I say it's wrong in principle just to focus on the dedicated funding line. It's not in accordance with how the strategy is drafted. And then, under that same heading, total government funding for active travel, because Table 1 provides an estimate of the total financial resources across government. So again, it's stressing the global nature of the figure.
And where are you reading from?
Sorry, it's on page 12, under this heading at the bottom of the page, total government funding.
Yeah.
And the first paragraph under that, Table 1 provides an estimate of the total financial figures across government. And so there are 2 points being made here. Firstly, that it's a total figure, and secondly, it's an estimate. And you find that in the text which follows as well, when it talks about the decisions being dependent on decisions by more local bodies. Next paragraph talks about projected investment, and third line, an assessment of proportion of investment. You get it again, references to estimate. And the fourth paragraph at the bottom of that page, these figures will be updated in future statutory reports to Parliament to reflect further investment from a range of emerging funding streams. So the strategy specifically envisages that by the reporting mechanism in section 21, the figures will change.
Although reading that naturally, it says updated to reflect further investment rather than reductions.
Yes, it does. It's contemplating an increase, but it's specifically contemplating an increase, but it is, by talking about an update, it's envisaging that the figures you see are not the final figures and are not fixed figures.
And we, even though we've now come to the end of the period, we've got no better clarity about how close to the actual figures you got.
No, we're not. And tends to, for the previous strategy, the report to Parliament was published at the same time as the issue of the new strategy. So if that process is followed again, that's when we might get some clarity. And further, even to the extent that it does, as my Lord says, refer to further investment, contemplates additional, not reduced investment. That further investment could be in funding streams 2 and 3. And if that's what happens, then that contemplates that funding stream 1, that dedicated funding, could reduce without the total figure reducing.
But I thought it become clear that that's not the basis upon which the decision was taken by the Secretary of State. There was no revised estimates of lines 2 and 3.
No, there was no revised estimate, that's correct. But this deals with the fact that the figure as a whole is an estimate. And therefore, even without having to do a sort of mid-strategy review to see where you are, you can make a reduction knowing that the strategy envisages the potential for other streams to increase and therefore potentially offset that reduction. And as I said earlier, it's not a theoretical or unevidenced hypothesis, because it's exactly what happened in the first strategy.
Some people might think that the financial situation the government's in has changed significantly since that happened.
Yes, I accept that there may be particular reasons why the first strategy, so much money was spent in that period, but at least at a high level it indicates that matters are not fixed, and you can't decide whether you've achieved the resources specified until the end of the period or sometime after the end. And then continuing with the document, so then that's the text which precedes Table 1. Table 1 itself, again, entitled Total Government Funding. And second column is projected investment. And you have the total figure. So broken down, but it's still looking at the total figure at the end. And my learned friend refers to footnotes 8 and 9, which rightly, as you say, do refer to those being estimates because of the nature of those funding streams. And they are particularly liable to change because of the nature of them. But that doesn't take away the point that it's a total figure, and if those funding streams do change, then that has the potential to offset the first active travel dedicated funding reduction. And it means you can't suggest that there's non-compliance simply by focusing on that first line in isolation.
Just for clarity, Table 1 is dealing with both revenue and capital, judging from the first line.
Yes.
So it brings the two together. Whereas, by contrast, what we've got in the witness statement, Tables 1 and 2, splits between capital and revenue, but is looking at line 1 only, not total funding.
Yes, that's correct. Then the next subheading in the strategy is performance monitoring. Again, which implies, in my submission, to some extent at least, a flexible approach whereby you may need to be responsive to what is happening. Again, indicated that an overly strict and prescriptive approach to those figures in Table 1 is not consistent with how the strategy is drafted and what it intends to say.
But you can't use the strategy to interpret the statutory provisions.
No, I certainly accept that. But assuming that the strategy is saying it's a total figure that's an estimate and therefore you can reduce one line without being inconsistent with the strategy, you are, even on Melinda Friend's argument, you're then not in breach of Section 21 because you are acting consistently with your strategy.
But Section 21 doesn't impose a duty to act consistently with the strategy. So it might be, you might be tilting at a windmill.
Yes. So it imposes the duty to specify the resources. And if you specify the resources in a global way which is only an estimate, if you then reduce them,
This goes to the question as to whether it's a variation. You're saying if it's consistent with what the text of the strategy, it's not a variation.
yes.
But then would it be permissible to have a strategy which says these figures can be varied? And then submit, well, as a result of that, I'm acting consistently with the strategy, therefore I don't need to go to the statutory process for variation.
Yes, in my submission, it would be consistent to have a...
Merely by the drafting of the strategy, you can actually circumvent what's in the Act of Parliament.
Unless you do so in a... Presuming it's not in a deliberate abuse, but if the if the figures are an estimate and you put a range, for instance, in your strategy.
Yes, well, you had a bit of text earlier on, the further investment, that's going up. If the text had said it could go down as well, would you be able to say, if it goes down, it's not a variation? Because look at the text of the strategy.
Yes.
I see.
Yes, one way to do that could be to have a figure and then to say it could be within this range, or indeed not to have a range at all. But if the nature of the sum is that it is inherently going to be an estimate and a projection, I wouldn't say it's defeating the purpose of the statute by drafting it in that way. That's simply reflecting the reality of the funding.
If it is an estimate, as opposed to a decision as to how much money will actually be made available. Yeah. Okay. I follow. Thank you.
And then there's one point. Those are my points on the strategy itself. There's one relevant point of evidence, which is background to the strategy, which is in Matthew's witness statement at supplementary bundle, page 44.
Paragraph
65.
Thank you.
Miss Matthew, first line says, as noted above, dedicated funding through AT is only part of the much bigger and more complex funding landscape. Developments in other funding streams could well offset or even outweigh the reduction in dedicated funding during the second strategy's period. The department's estimates of the amount of funding that's spent on active travel from the CRSTS and Levelling Out Fund, for example, are deliberately conservative and may well turn out to be underestimates. And then she continues along on that theme. So that further indicating that treating the strategy as an estimate, firstly, and secondly, dealing with it in a global way such that even if you reduce one funding stream, the total figure might not go down because other funding streams go up, and other funding streams which were deliberately conservative, as Matthew says. That's entirely, it's what the strategy is intending.
But one way of dealing with that would be to say, this is our estimate of the extent of the conservatism, and we think it's roughly about 200 million. But no one did that.
No, I accept that.
And there's another source there which hasn't been counted, mentioned in the last sentence. But again, no one thought it appropriate to estimate that. And within the context of your submission, that to some extent this is estimation, not entirely, but to some extent.
Yes, no doubt it could have been drilled down into more. But there is no challenge that the Secretary of State failed to have regard to the strategy and didn't sufficiently interrogate it. It was one of the grounds below, and it's not been pursued. So the simple question is whether the strategy itself is flexibly enough worded that the Secretary of State's decision can be consistent with it. And I say, on a fair reading of it, it is flexibly enough drafted to do that. And final point, just on the sums involved. And it's still relevant to this point about funding streams 2 and 3 potentially increasing and offsetting a reduction in funding stream 1. The total figures are 200 million or so, slightly less we say, but it doesn't matter a great deal. 200 million reduction. The total figure is 3.5 billion in table 1. So what's been reduced is about 5% of the total figure. And So it can't be said that such a decision is to reduce one funding stream by 5% of the total is necessarily inconsistent with that strategy which words it in a flexible way. Even if you look at funding line 1 on its own, 200 million is obviously a bigger percentage. It's about 17% of the total in the funding line 1. But as I say, it's properly done looking at the global figure, not just one funding stream.
So do we know what announcement was actually made when the change came into force by the government about the change, or by the department?
The change in terms of the reduction of 200.
Yeah.
It's that document which you've been taken to at pages 228 and 229 of the core bundle, the ministerial statement, which doesn't expressly state the figure.
And I mean, does this say that there is a reduction, or does it say, in fact, we're just carrying on without any change?
In my submission, it doesn't say that we're carrying on without any change. It doesn't expressly say there's a reduction. The relevant
It doesn't actually deal with the point, does it?
Not expressly, no. The relevant paragraph is the penultimate one. We remain committed to supporting all forms of transport and have invested 850 million in active travel 2021 to 23. Despite the need to deliver efficiency in all areas of the budget, we still commit to spend at least a further 100 million capital. So that 100 million is the total of the 50 and the 50, which remains after. So it says what's left, but without saying what's been taken away.
No, but what it doesn't say, because I understand your second point, which, as I hope I summarise fairly, it's okay, accept all that Mr. Forsyth has said as being accurate about the statutory interpretation. Actually, the strategy we drafted was cleverly enough drafted to allow us to do all this as it is. But then when one looks and tests that against what they announced, they didn't say, actually, we're still complying with the strategy. What they've said is, we're only giving you 100 million.
I say that's a matter
And what do you say the answer to that point is?
The nature of this document, the original ministerial statement, isn't to go into the detail of the cycling and walking infrastructure strategy. It's a statement to Parliament. The context being that in November, the Chancellor, as I said, in Parliament said there was to be this spending review, or certainly funding, capital spending review, and then to be completed by March. And so in March, the Department for Transport came back to Parliament to announce what they had done as part of that process. They only went into so much detail as you see on these 2 pages, but given that the reduction we're talking about was only 5% of the total active travel resources in the strategy, let alone the department's entire capital budget, which is obviously vast compared to that, you wouldn't expect in my submission, or you might not expect the statement to delve into that amount of detail.
Just so that you can deal with the point expressly, one way of reading, despite the need to deliver efficiency in all of areas of our budget, so despite the fact that we've got to reduce our budget, we will still commit to spend at least a further 100 million. That suggests that there is at least a change of sorts in the active travel budget, which we now know why it's drafted in that way from Miss Matthews' statement.
Yes, I accept that it does imply a change of sorts, that's right, but it's not purporting to assess whether that change is consistent or inconsistent with the cycling strategy. It's simply reflecting the reality that there has been, in terms of the specified figures, a change.
Thank you.
Just further, those are my submissions.
Well, thank you very much indeed for your help. Yes, Mr. Fawcett.
Most of my points in reply have been taken up in questions from the court, so I won't labour matters. Can I just deal first of all, though, with the estimate point?
Yeah.
Just in very short summary. It is not an estimate. It couldn't be an estimate. It is specifying the resources to be made available. And it does so by, first of all, having a dedicated capital fund, dedicated funding in line 1. And then, as I made detailed submissions on in opening, bona fide projections on best estimates and best evidence, on best evidence of what would be spent from the other pots.
And what about Mr. Flanagan's point, which is, well, this is all just a total, and in fact, you're probably going to have been overspent in any event.
Well, a number of points. First of all, that was never said at the time. Secondly,
when you say at the time, you mean at the time of the
decision.
Yeah.
It was the words that my lord has just pointed my own friend to clearly tell us that there's a reduction, and we had to get the reduction kicking and screaming out of the Secretary of State to be a bit because, but there was a reduction. The decision was to cut £200 million from line 1. We know that was the decision now, because Miss Matthews tells us. That's
about 200 million.
About 200. Sorry,
yeah.
Sorry, apologies. That's what whenever I say 200 million.
Yeah, no, I understand.
So that's one side of the equation. And what have we got on the other side of the equation? We've got nothing in the ministerial statement saying, don't worry, it's being offset elsewhere. There's no claim of any offsetting increases in the ministerial statement or in Miss Matthews' witness statement at the time. She's not saying, don't worry, it was going up by 200 million elsewhere. There's still no evidence that those lines mean that the total will be met. And the highest Miss Matthews can put it, and she puts it very fairly, is that it is hoped that the reduction will be made up. That's JM65, the same paragraph my own friend goes to. But even now, there's no suggestion, no evidence that it has been made up. And, my lord, once one knows that the total of Table 1 has been reduced by... Once one knows that there's a decision to take 200 million out of Table 1, there's got to be some offset somewhere, to make my learned friend's point. And of course, there could be evidence before this court saying, don't worry, it's the same position as under Swiss 1, we've massively overspent under different heads. But even now, 2 years later, there's no such evidence. So that deals with the estimate point. If I can come very briefly back to the statutory interpretation point, and it was suggested that the Secretary of State can decide that it's not going to be a variation, that it's a Wednesbury, that she could just simply say, I don't think this needs to be a variation, and that would be subject only to Wednesbury. The problem for my own friend is that the Secretary of State has never put her mind to that question. There's no evidence that she ever asked herself, do I need to vary the Swiss? is this a variation for the purposes of section 21? And so the suggestion that it was for her to decide rather begs the question, where is her decision on that? Secondly, Miss Matthews' evidence doesn't claim it's not a variation. And thirdly, there's not been any ex post facto statement or exposition that it has been judged not to be a variation. So even if my learned friend's new point on that was correct as a matter of law, it's not correct on the facts. But in any event, we say it's plainly a variation because the Secretary of State has decided not to make available 200 million of the funds she's specified to be made available. It's really as simple as that.
And how do you, Mr. Flanagan after lunch, his second point on the construction was that, in fact, when you look at it in drafting, it's all estimates, and this sort of reduction shows that while sometimes it might be a variation, in fact, if it's for us to judge whether it is, it isn't a variation.
Well, I think that would mean that my learned friend is inviting the court to make the judgment that he says is a judgment for the Secretary of State to make. The key point is, in my respectful submission, that if this was the line, that as a matter of Wednesbury reasonableness, I don't think 200 million off 300 million is a variation, then one would expect to see that in writing somewhere. We haven't got it. My learned friend, at one point in his submissions, said, at least I wrote down, that he said that the SWIS is a statement of intent at the outset. And that is why I went through at some length my 10 points as to the period over which it spread, that it had it was speaking continually across the period. And it's that way of looking at section 21 which is why we're here. That it's not just a snapshot at the outset, it's the strategy for the period. The final point I wish to make a very short submission on is my own friend said that clear words are required to remove the discretion. He said that twice, but that's not the law. His own authority, Shrewsbury, and indeed the paragraph he quoted at paragraph 50 of Shrewsbury says the opposite. This is page 128 of the bundle.
Which one?
Sorry, the authority bundle. The Shrewsbury.
Yeah.
My learned friend's submission is that if you wanted to remove the discretion, the prerogative discretion, there's got to be clear words in the statute. But here, the court is saying there's no dispute that whatever the scope of the Secretary of State's common law powers, they may be expressly or implicitly excluded by a statutory scheme. So there's not a case of the statute has to say, and the Secretary of State's discretion is hereby excluded. The exclusion of that discretion happens as a matter of law in the light of the FBU case, which I've taken the court through. And indeed, the position in FBU is the same. It didn't expressly remove any discretion, but the court took that as having been the effect. So, for all those reasons, in my respectful submission, the appeal should be allowed on both issues, unless I can assist the court further.
Thank you very much indeed. Well, thank you all very much for all the very helpful submissions, and to your respective legal teams as well. We're very conscious of all the hard work that goes into preparing this. The court will take time to consider its judgment. It will circulate that in draft. The draft will come with the usual embargoes and confidentiality provisions. Please comply with them, because it's very disappointing to have to threaten people with contempt of court because of inadvertent disclosures. And we will, as ever, try and deal with it as speedily as possible. But thank you all very much indeed.